wait a minute, they have an easement here, they can park there, you know?
Yeah. Hey everybody, welcome back to the Real Estate Show. I'm Tiffany Weber with Thomas & Weber and joined today by Erica Henson. Welcome back.
Thanks, Tiff. Glad to be here.
I'm really excited. You know, we're recording a lot today and we got a lot of different topics to cover, but this first one that we're going to go over is the types of easements you will see on a plat. And they're plentiful.
Yes, they are.
For lack of better, of a different way to say it. There are many, many. And I think most people don't really look at their plats when they're buying property, other than to say, yep, it's the third house in. And,
sure.
Or when we're going through a closing, like, oh, yeah, that's the Smiths and that's the Joneses. And, yep, there we are. So I wanted to take a couple minutes today and go through the different types of easements that you'll see on a plat. Kick us off. What are some of the common ones that you think of when we're looking at a plat that we'll probably see noted?
Yeah, so the first one that comes to mind is the right-of-way easement. These are easements that give a particular party, a right to use a particular piece of property, particularly for maybe roads that are coming through. Sometimes we see turn lanes right into someone's property. Utility easements. The cable company or the cell phone company might need a utility easement across your property. Duke Power, Duke Energy is one of the big ones that we usually see on a plat.
Yeah.
Yep.
And also, I just realized that it might be helpful if we define an easement for people. I will often jump in without realizing maybe not everybody knows the technical definition of an easement. And we see this a lot, that people will assume that someone having an easement gives them maybe greater rights than they actually have. Just straight up law school definition, an easement is the non-possessory right to use the land of another. And the words right to use are the key portion right there. Nowhere in that definition doesn't include ownership. So I think people are so reluctant to grant easements or seek easements because they have this preconceived notion or a misunderstanding of the concept that it will give away ownership. You are sharing some of the rights in your bundle of sticks, but you're not giving the whole kit and caboodle away. So let's start with, you already talked about utility easements. Where are those typically located on a property?
Yeah, so when we look at a plat, a utility easement is usually across the front of the boundary line, like in front of the home or along the sides of the particular parcel, really so that the utility company can have quick access to what they need. Their underground lines usually, or drainage easements or things like that run across the side or the front. Occasionally, we'll see an easement across the back of the property, sometimes for power lines and things like that, but mostly I would say along the front and the sides of the property.
And I think over time, that has played into why setbacks are what they are too, because it is so typical that the utility easements are located in such a way so the setbacks encourage or make it easier, I guess, for the properties to be platted that way and the utility easements to be granted that way.
Sure.
Now, the right-of-way easements, so I think of, roads, whether public or private. That would be one. This is one that I hadn't thought of, but we're at the lake, so it could be a path to get to the water, because that's your community access. It doesn't necessarily mean they own it. It doesn't mean that they can launch their boats from there, but they may have a right in your community to walk through your lot. We'll see that sometimes in big neighborhoods that have greenways or parks attached to them. So there will be some cut through between two lots to get to that area, and it's open to the community. Now, on those types of right-of-way easements, there are usually some things that the owner can't do anymore. Like, you can't build.
Sure.
You can't put a structure. You can't plant trees, maybe.
You can't do anything to obstruct access to the utility. I have a family member, I'm not going to name any names, that doesn't like the utility to park on his lawn. Oh, it's going to mess up my lawn. And I'm like, wait a minute, we have an easement, or they have an easement here, they can park there,
Yeah.
And they try not to disturb your
Yeah.
property as much as possible, but you cannot obstruct them, you cannot prevent them, you cannot block them or put anything in their way. So it definitely impacts your ability to use, but hopefully as minimal as possible.
Yeah. And that's why the reviewing the plat, preferably before you even put in an offer, because if that's a deal breaker for you, then you should look elsewhere before you put down any non-refundable money. This one, drainage easements. These are less common. I shouldn't say less common. They don't necessarily affect every lot in a neighborhood, but depending on the landscape, the stormwater management guidelines within a particular municipality, there can be drainage easements across one or several lots just for the purpose of runoff. Have you seen that?
Yes, we actually owned a home that had a drainage easement across the back of it. It backed up to a golf course, and just the lay of the land, it was a natural runoff area for part of the golf course. So there was a drainage easement across the back. And while some might say, I don't want I don't want a drainage easement, it was actually very necessary to make sure the property did not flood and cause extensive damage.
Yeah. Another one that this is less common, conservation easements. Some of the purposes of these, the agriculture, maybe that's not forestry, making sure that the nature is being kept intact.
Preserved.
Those are for sure some of the things that can be used for conservation easements. But I also think some of these can be imposed by, like I think of City of Charlotte, they may have like tree save areas that you're required to have. So you can consider those effectively easements to the city that you can't cut your trees down or whatever that may be. But those conservation easements are interesting because then you can bring in a lot of people talk about land trust because it's the buzzword on YouTube, and I want to put my property into a land trust. But in the state where we practice law, those are really only for conservation purposes.
They're rare.
Yeah. So those conservation easements might be in favor of one of those land trusts, and lots of complexities there. Now, there's another one that these wouldn't necessarily be on a plat, but they could be if they have been in existence long enough or they have been adjudicated. And those are easements by necessity or prescription. I think of a case that I had several years ago that we actually got to argue at the Court of Appeals for. It was exciting. That I like to call, when I explained it, I said, my clients have an easement 5 different ways. Any one of them is sufficient, but they've got it by grant. And if you say the grant fails, they've got it by prescription. If you say prescription fails, they got it by necessity. If that fails, you got it by implication, and on and on and on. So these are kind of near and dear to my heart. But I'll have you talk about prescriptive easements, but easements by necessity, when you've got a common owner, property is then split apart by that common owner, and the easement becomes necessary due to the split. And that was one of the, I think of this case, our Mr. Developer, Mr. Owner, he split up his lots, but because of how he split it up, there was a need for circumnavigation around the buildings. Otherwise, big trucks wouldn't be able to get through, and the nature of these businesses were that they needed big trucks every day. So that would be an easement by necessity. That goes up to the court, and the court declares, yep, it's the real deal. Then it's going to be noted. If that's ever, replatted in the future.
Sure, it would be drawn on the plat at that time.
Yeah. Talk about prescriptive easements.
Yeah, so prescriptive easement is when you have someone who's been using a particular piece of property for whatever reason, one reason or another, over a continued period of time, a long time, years of time, and there's been no objection. So basically they have, in simple terms, they have earned a right to that use of the property now. They're not, they won't own the property as we talked about in the beginning, but they have an easement. They have a right to use the property just by historical use without objection to it. So again, this is long-term use. This isn't 2 years, I would say. This is much longer than that. And again, you wouldn't see it on the plat until it has been probably adjudicated, right? And then once the plat is redrawn or created, then you would see it. But initially, you wouldn't see something like this on a plat. And we don't typically see it. You wouldn't see easement by prescription on the plat. It wouldn't look that way. It would just show an easement
Yeah.
The person who's reviewing the plat really wouldn't know how it, the history behind it. It would just show an easement.
And it would, like a lot of easements where it refers to the deed book and page where it was created, we'd have that too, except when we go to that deed book and page, it would be a clerk's order or, it'd be a judge's order that had been recorded in the Register of Deeds. I don't know if you remember our law school classmate, Tim Fridley's acronym for the elements, or mnemonic for the elements of prescriptive easement. I can't say it on the camera, so we'll talk about it when we're done recording. But every time I talk about prescriptive easements, I think of his.
He had an inappropriate acronym for like open, hostile.
It was adverse, hostile, open, notorious, exclusive, continuous.
Okay. But he had his own acronym. Okay, got you.
Specifically with the H. It'll come to you after we're done, I'm sure of it. So one thing, I had kind of a little general list here, and one thing I didn't put on the list, but is very relevant here at the lake, are septic lots.
Oh, yes.
Septic easements. Some of these septic issues will result in I have lot 197 and my septic lot is 197A and it's located somewhere else on the plat, but it runs with the land. They're not always separate septic lots, but you may have your neighbor have a section of their property that they can't build on because that's where your septic is. And I think those are super important to note as well.
Sure. And now I think, when new plats are created, let's say a developer is looking to create a plat of a particular piece of property and they need to create septic easements from across multiple lots. Particularly Iredell has become very specific about the language on the plat with regard to the septic easement to preserve the easement itself, to make sure that the owner of the property or whoever who needs the easement, that they don't have any issue later on down the road with access.
Yeah, that's a really good point. We've lived through many of those lately.
We have, and I'm glad you hit on that because that is one easement that we do see a lot across plats in Iredell.
Yeah. Well, I feel like that hits on, the major things that you're going to see on a plat. Of course, we could probably break up every single one of these and do a whole episode on it, but that's, we're going to save everybody today. Well, we won't get too nerdy about it, but thank you so much for taking the time to talk plats and easements with me today, Erica.
Thank you, Tiff. Glad to be here.